If I'm paying for a child that's not mine, I hope you guys pay me that back.
I am stuck in a situation where my therapist has me in a dialectical behavioral therapy.
I think I deserve to get my rights back, being that he got sole physical and legal custody only because it was on the divorce judgment.
All matter of Thomas Laforus versus Rebecca Ledbetter. Mr. Laforus, this is your motion regarding parenting time, is that correct?
Yes, Your Honor.
All right, what are you seeking to change?
I'd like to change it to standard parenting time where during the school year, she would receive Jacob every other weekend, beginning on a Friday after. Well, because he's in pre-K, we could either do Friday evening to Sunday evening, or we could do Friday morning to Sunday morning. I guess whatever is standard for the courts. And then
Ms. Ledbetter, what is your position on changing the parenting time?
I think the best interest for Jacob is to see more of me, actually. I do work a lot. I work 2 jobs, so I would obviously need a daycare and I would pay for a babysitter if needed. I would like to get him, and I would agree to this if we could gradually do a whole week on, a whole week off, a whole week on, a whole week off, 50-50. No more he's up here and I'm way down here. I've proved myself in the last 3 or 4 years, and I think I deserve to get my rights back, being that he got sole physical and legal custody only because it was on the divorce judgment, and he divorced me when I was incarcerated so that it would be default and he would get what he wanted. So I want my kid back, and I think it would be good for him to spend a half, especially since they moved closer. I can pick him up from school. I want to get him into activities.
All right.
I want
All
to
right.
be able
Thank you, ma'am.
Oh, okay,
Thank you.
You're welcome.
So I'm confused. Sir, you filed this motion?
yes, Your Honor.
And
All
I
right.
did file a motion.
Hold on, ma'am. Hold on. All right, sir. So you filed the motion, and your request is that she have standard parenting time?
Yeah, the purpose for that, Your Honor, is we had it, our prior order from, I don't know, a couple of years ago, had us doing it as we communicated. She would pick them up once a week on Friday, no overnights. I think it's been for like the last year and a half that was the standing order.
All right.
It started
All
off
right.
good.
And then Ms. Ledbetter, you were saying something about a motion. Have you filed a motion?
Yes, sir. I did. I put in a response, just stating that I would agree with that if we could possibly do maybe mediation with the front of the court. And I would request it to just be me and Mr. Laforest. He does put in his wife, the stepmom, and I think it would be better for Jacob if it was just the biological parents that have the mediation. And I am looking into changing of custody, so I could get that back.
All right. So the way I'm looking at this is there's a current order that says that Ms. Ledbetter has parenting time every Friday. Pickup and drop-offs will be as the parties agree. That's what your current order is that correct?
Yes,
Yes,
sir.
Your Honor.
All right. And Mr. Laforce, you're asking that that be changed to standard parenting time, so it'd be every other weekend, but it'd be Friday and Saturday overnights. Is that correct, sir?
Yes, Your Honor.
All right. So Ms. Ledbetter, are you in agreement or disagreement with that?
I would only agree to it if in time when Jacob feels more comfortable, if we can increase that weekend to an entire week.
All right. Well, I mean, it's hard to build things like that. I mean, the two of you are certainly free to reach any agreement that you want. So this is kind of where we're at. Since you're not agreeing to the standard parenting time at this time, then it would remain as is. Mr. Laforus, you would have the right, if you want, to have this matter set for a hearing since it's your motion. And the court can make a determination, or the parties can also try to participate in mediation first. See if you reach some type of agreement there. If you don't reach an agreement in mediation, you would still have the right to come before me and have a hearing. What are your
Let's do
thoughts,
that,
sir?
Your Honor. Yeah, let's do
Sure.
that. That sounds good, Your Honor. We'll do the mediation first, and if we can't resolve it there, then we'll set it for a hearing.
Amanda, you're
Thank
okay
you.
with that?
Thank you. Yes,
All
I
right.
am.
Then is we'll refer this matter out for mediation. If there is no agreement met, then we would set the matter for a hearing. All right, thank you both for appearing. You're all
Thanks.
set.
Thank
Have a good day,
you.
Your Honor.
Thank you. Call the matter of Jerry Gildner versus Catherine Arms, file number 10-13536DM. All right, we do have the parties present. We have a motion filed by Miss Arms at 10:15, which is the matter the court's addressing. We also have a show cause at 10:30 regarding parenting time complaints. So both parties are here, so we can certainly address them both. Miss Arms, your motion regarding parenting time, what are you seeking to do?
I'm seeking to have the parenting time up to my daughter. My daughter turns 18 in 9 weeks and 1 day. She's a busy senior taking college classes on top of her high school classes. So she's a very busy child and works to save up money to go to North Central next fall.
Okay. And Mr. Gildner, what are your thoughts on the parenting time motion and where we're at with this case?
Yeah, Your Honor. I would just like, I'd like to be able to see my daughter. You know, I'd like to be able to talk to her without, you know, worry of the other party becoming involved somehow. I mean, she's going to be an adult here in a couple months. And I understand she's busy. I talked to her last night. She was talking about college and stuff. So, you know, I just miss being able to spend time with my daughter. I would like some kind of visitation set up, at least in the meantime, you know, just until she turns 18, so there's no interference.
All right, well, if the parties want to proceed forward then, and then as to the parenting time complaints, Mr. Gildner, anything you want to say on those?
I would just I would like to let the court know, the last time we were in court together with this, Mrs. Arms was found in contempt of denying my parenting time. She was fined $100. So I just want to make the court aware of that.
Well, are you asking for a hearing on the parenting time violations?
Yeah, we could do a hearing, but I think by the time we're going to get a hearing, she's going to be 18 probably. So, I mean,
I can do a hearing on April 14th.
okay, yeah, definitely.
Okay. All right, we'll hear both matters then on April 14th. That is a in-person hearing.
Yep.
At 1 o'clock. I would need to meet with your daughter at 12:45. She has the right to express to me any preference that she has. So I would meet with her at 12:45. We would start our hearing in person at 1. Additionally, if you're going to have any witnesses or exhibits, those need to be, a witness and exhibit list needs to be filed within at least 14 days prior to the hearing date. And you also need to exchange copies of any exhibits with the parties. You do not need to file the exhibits with the court. You need to have them available for the hearing, but you need to exchange the copies between the parties within 14 days before the hearing. Any questions, Ms. Arms?
No, Your Honor.
Mr. Gildner, any questions?
No, sir.
All right, thank you. We'll see you here April 14th.
Thanks.
We're next on the matter of Tasha Butts versus Raleigh Mccluskey, file number 11-14145DP. Do you have anyone present on that matter?
Yes.
Good morning. We do have Mr. Mccluskey present. This matter is set for a show cause hearing, as well as then appears a motion regarding support. Mr. Mccluskey, it's your motion regarding support, is that correct?
Yes.
All right, what would you like to say regarding that, sir?
Tasha and I came to agreement to lower my support, what I could afford, about $250 to $300 a month. We came to agreement to get a loan. I did, to provide Kylie with all of her school clothes, 3 pairs of shoes, and to pay her cell phone bill for several months. And Tasha would lower the support to $250 a month. I contacted the court worker multiple times, and Tasha kept failing to meet me there or to go there after I'd done everything she asked. And my support said I can't afford that amount right now.
All right, did you and her have any written agreement?
I got it in text messaging from her multiple times.
Okay.
We were supposed to meet at the court to sign together, the worker told us, when I was up north working, and Tasha failed to meet me.
Okay. And in front of the court, any information on this matter?
He has expressed that to us, however, we would need her to sign off on that money that is either direct payment or arrears forgiveness. If they're willing to do a stip, then, you know, again, that's gonna require both of their cooperation.
Okay. And then as to the show cause.
So he was here before us last time on January 22nd, and we had adjourned the matter to allow the defendant a chance to file this motion, and that he was to continue to pay each month. His monthly support obligation is $534, and the current balance is $5,389.67. We received a $300 payment for this month, no payment in February, and in January, we received $250.
All right, Mr. Mccluskey, anything else that you wish to say?
Yeah, I paid every month.
All right, are you meeting, how much are you paying every month?
$250 to sometimes $300. I paid in person in Oakland County multiple times and on the website.
Okay.
I have all.
And what is your monthly support amount?
5 something.
Okay.
534.
February I paid also.
Do you plan to pay the $534 a month, or are you sticking at this agreement that you think you have with Ms. Butts?
No, I just can't afford the $534, sir. If I could afford it, I would be paying it.
All right, so we're here today on the motion regarding support as well as the show cause. I am going to deny the motion regarding support. I don't have Ms. Butts here to confirm any type of agreement to lower the amount. So the court is not in a position to do that without Ms. Butts agreeing to lowering it based on what the parties have. So that motion is denied. As to the show cause, we've not been meeting the amount, but some type of payments are coming in, but it doesn't appear that Mr. Mccluskey feels he can meet the amount that is ordered. So adjourning it doesn't make sense necessarily to me, because it doesn't sound like you would have you don't intend to pay more than the $250 or $300, which would still not satisfy the amount that's ordered. So given that, I am going to recommend a finding of contempt and the matter be set before Judge Hesselink. I do find that there is an arrears and that there is the ability to pay under this order, and the full amount is not being met. That with the exercise of diligence, there is a capacity to pay all or some portion due. I'm going to set it out to the May 9th docket for Judge Hesselink. I would indicate that if a payment of, has there been a March payment then, you said, I think correctly?
A $300 March payment.
Okay. So if $800 is received prior to that May 9th hearing, then that matter would be canceled, and then we would just proceed forward with any other potential show causes if payments aren't met. Any questions, Mr. Mccluskey?
Yeah, also Kylie's not even in school. I mean, what do I do about that? File a motion on that also?
If you have parenting time or custody issues or other support issues, yes, you would need to file a motion.
Okay. Yeah. All right.
All right, thank you, sir.
You're
We're all
welcome.
set. All right, we're here for a couple of matters. One is regarding the attendance at the SMILE program. I believe that is for Ms. Dork. Ms. Dork, have you done that or do you have it set up?
I do have one set. I had to change the date. The day that I was going to go, I had a seizure and I was taken to the hospital and I was admitted to the hospital all week. So I've only been out of the hospital for 6 days, but I was in for a full week. But I called friend of the court. They told me just follow through with the court date, and she registered me and everything for the April 10th one, I believe.
Okay.
So I'm gonna have
All
to
right,
do
that particular issue to a date after that. Obviously, if you attend it, then that court date would be taken off. Okay.
Okay.
And then we also have a hearing regarding any final custody judgment. Do the parties have an agreement in this matter?
We did have one before and we just did 50-50. It was just pretty simple, plain Jane. Like we didn't want to do child support or anything like that. And of course, we're going to make sure she has insurance, but it's just going to be 50-50 parenting time.
All right. And then, so were you told to put that into a more formal custody order?
I'm not certain, to be honest with you.
That issue, if I'm looking correct, is there was a recommended order, but in order to close out the custody case, there has to be a specific custody order prepared by the parties and reviewed and signed by the court.
I do believe the children are in foster care as well, or child in foster care.
Okay. So right now there's an open foster care matter. Is that correct?
That is correct.
All right. Is that going to be closed out soon, or what's the where are we at moving forward?
I asked yesterday and it's been 7 months and she said it's pretty much case by case. So we're just kind of doing what we have to do so we can end it and just move it along. So we don't really, we don't really know what to do. Okay.
Correct. We can help with that.
All right, so there's a standard form that you can fill out and just put in the information that's appropriate to your case based on what the prior court order was, but we do need that final paperwork. So Ms. Dork, perhaps you could contact the front of the court, ask for or come to the front of the court and get the paperwork, or contact them and ask for it to be sent to you. But the parties do need to complete that paperwork.
Okay. And what specifically is the paperwork called?
It is the final custody judgment.
Oh, custody judgment. Okay.
I believe that's something I have to fill out, right? Because I was the one that filed for custody.
Well, ultimately, anyone can complete the paperwork. You both will review it. Yep.
Okay.
All right, and front of the court can help you with that too. Okay.
Okay.
Any questions?
No.
All right, thank you both for being here. Then you are all set and can sign off. And in front of the court, what is the status of this matter?
The Uniform Child Support Order dated April 3rd, 2014. The plaintiff and the defendant was ordered to maintain health care coverage. Around January 15th, the friend of the court was informed that the defendant may not be maintaining health care coverage. On January 16th, the friend of the court mailed the defendant a letter requesting he provide verification of health care coverage to the friend of the court by February 6th. There has been no contact with the defendant, and the notice to appear for this hearing was mailed out on February 10th. The plaintiff did stop in yesterday, about an hour before close, to drop off some court paperwork, and she did indicate that the defendant provided a copy of insurance by text to her, but no physical card.
All right, thank you. Mr. Grubauer, what would you like to say?
He does have health care, and I provided her with like she said, the text message of the one.
All right. Is that correct, Ms. Musto, that you do have proof of the coverage and have the information now?
Yes, now I do.
All right, and Mr. Gruba, are you able to provide proof of that coverage then to the front of the court also?
Yes, sir, Your Honor.
All right, any reason you can't do that within the next 7 days?
Do I need to bring in the physical card, or can I send them the electronic version?
For the court?
Well, electronic version, I mean, if you can supply it by fax, but
Right.
email wouldn't be appropriate.
Right, you need a paper copy, so you can email or fax the proof or bring a copy in, okay?
Okay.
All right, you should do that within 7 days, okay?
Yes, Your Honor.
All right, thank you. Thank you both for being here. You're all set.
Your Honor, I have one more thing to add or say.
Okay.
Josh, our son's last name is changed to Mastof. It's not Gruba anymore. And that his insurance through his dad's insurance, it's technically pointless because I can't use it because Josh won't change our son Joshua's last name to his legal name on his insurance. And I've been trying to get him through on ABA services and like other services that he needs for his autism, and they won't approve him because Josh will not change his last name to his legal name on his insurance.
All right, Mr. Gruba, do you understand that?
I do, but I have no record of his name change, and they need something of his name change so that I
Ms.
can.
Smith, provide him a copy of the order from the name change, and then he can go ahead and take care of that.
Okay, yeah, I would have known that. I would have done that right away.
Sure, no problem. Just get that paperwork to him, and then Mr. Gruba will follow through with that, okay?
Okay, thank you.
Yes, Your Honor.
All right, thank you. Of Brandon Geisenhoff versus Sabrina Mastof, file number 16-16512DS. Do you have anyone present on that matter?
Yes, we do, and it's pronounced Geisenhoff, so you know for next time.
All right, ma'am, thank you for that correction. Front of the court, what is the status?
This hearing was adjourned from December 11th when the hearing was recalled after a bench warrant had been recommended due to the defendant's non-appearance, and the recommendation for an issue of a bench warrant was withdrawn. The defendant was to make a payment of $40 by December 13th, and this hearing would be removed if the defendant pays a total of $290 prior to today's hearing. The defendant did make a payment on December 16th of $40, but only $8.15 dispersed to this case. There's been no additional payment or contact since. The defendant's obligation is $86 monthly, and a balance on the account is $1,388.19.
Thank you. Ma'am, what would you like to say regarding this matter?
I will tell you the same thing I tell Emmett County. I am stuck in a situation where my therapist has me in a dialectical behavioral therapy, and it is going to take several years for me to be able to even go out and get a job. I am currently filing for disability. I have one denial already, and I'm working on appealing it. There is literally nothing I can do right now.
All right, and have you provided any of that information to your caseworker as far as, Social Security filing and anything from any doctors?
I do not know if she has any cases of these, but I have emailed some of it to her. I can email the rest of it to her this afternoon, but if she's looked at them, I do not know. But I know that I have sent them some of the information in an email. I did not send the denial information because I did not get that from the last time that we have talked, but I will send that in as well.
All right, front of the court, as far as the Social Security case and anything from any doctors, do you have any of that information at this time?
I do not. Emails are intended for us requesting information. So if she was to have emailed something, I don't know what that would have been or when.
Okay. All right. So what I'm going to do, ma'am, is adjourn this matter out a little bit. I'm going to give you a chance then to get that paperwork together and provide that to your caseworker.
All right.
I'm gonna go to May 14th. That should give you plenty of time to get, documentations from any of your doctors or treating providers. So we're looking for things that give their opinions on your ability to work, as well as then if you can just provide proof that you do have that ongoing Social Security claim, okay?
Absolutely.
All right, thank you. You are all set for today.
Thank you. You have a great day.
Elliot Blumberg on behalf of Mr. Dash, who's also appearing via Zoom from a different location.
Thank you. And Mr. Dash, I just want to confirm that you can hear me okay?
Yes, again.
All right, and in front of the court, what is the status of this matter?
The defendant has a support obligation of $317 and a balance of $4,312.50. There's been no payment received since the Uniform Child Support Order dated October 29th of 2024 with an effective date of April 5th of 2024. The defendant has had contact with a friend of the court that he's making payments through Venmo and providing receipts to the attorney. The friend of the court did contact his attorney on February 3rd with a request for a return call in regards to verification and questions regarding the final custody paperwork, but I have not heard anything back.
Thank you. Mr. Blumberg, what is the status of this matter?
Judge, I'm a little confused, candidly. In August of 2024, the parties entered into a mediation agreement that required my client to pay $2,000 a month in child support. $1,500 of that was credited to him each month because Mr. Grez is living in his home. And so that instead of paying rent, $1,500 of that $2,000 is to be paid, credited for child support. I know that he has been paying her directly. As recently as a week or so ago, he gave her an additional $500. So regrettably, the mediation agreement apparently has not been reduced to an order. So I'm not exactly sure where this other order came from, the one that the friend of the court just referenced.
Well, I know Judge Mertz signed some temporary support orders back in October. I think that's they're getting their figures from. I see the mediation agreement in the file. I see that looks like you might have had a hearing in January in front of Judge Mertz to adopt the mediation agreement. It looks like the other side filed their own proposed judgment, but we don't have any finalized judgments. Have the parties reduced all that to a signed order yet from the judge?
Unfortunately, no. I mean, it's prepared. It just hasn't been presented to the judge. So I guess what I would request is that you put this off for about 30 days till we get the order entered, and then we can recalculate giving him credit for what he's already paid to her directly and the terms of this mediation agreement.
All right, and given the fact that he is making payments, there's just kind of essentially a issue with where we are at paperwork wise. We've got to get that cleaned up. I do think adjourning it, there is good cause to adjourn. I'm going to go to May 14th just to get a little bit extra time because I know how paperwork can go sometimes. So perhaps the new order will simply take care of all this, but just make sure, this is being addressed because there is that current support order that's out there. So any new order is going to need to address all that back issue and effective dates, but we'll adjourn this then to May 14th.
So Judge, I just want to be clear, between now and then, Mr. Dash is to provide the friend of the court all of the documentations of direct payments that he's made?
They're shaking their head. We don't need that. We just need to clear that up and then whatever order that you guys prepare. And then what's been paid can be identified through that.
Okay, but again, my understanding is based on what I've heard today, the friend of the court says there's an arrearage that is owing. Is that right?
Correct.
We can handle it all hearing. My assumption is based on what's completed and filed, it may take care of everything.
Yeah, I think if the parties and what agree and provide proof to the front of the court that there's been a credit and those things have been paid, then that'll certainly take care of the balance here.
We could do that on the record at the next hearing if the other if the plaintiff and their attorney appear, we can handle the direct payment credit.
Sure, and they may address that too in their actual judgment they submit.
Judge,
all right, Mr. Blumberg, if you have questions in the process, just feel free to reach out to the caseworker.
Sure, I'm sorry. I know for a fact that on May 14th, I will not be available.
Okay.
Can we do it the week either before or the week after?
May 19th at 9 o'clock. I could do it then.
I'm gonna be gone that week, so.
Well, you want to go with try April 23rd and see if we can get the paperwork wrapped up by then?
Sure. That would even
So
be,
April 23rd at 9 o'clock?
either of those dates would be fine.
All right, so we'll do April 23rd at 9.
Great, thank you.
All right, thank you. You're all set.
The plaintiff has a support obligation of $122 and a balance of $1,249.50. There has been no payment since the Uniform Child Support Order entered on August 13th of 2024 with an effective date of June 3rd of the same year. The friend of the court did receive the plaintiff bank statements and a copy of the income withholding that was sent out to Social Security. It does appear that he does receive that. It's just no income withholding. The income withholding had been mailed out to them on February 27th. I did have a discussion in regards to making self-payments, but he had some concerns about meeting the obligation.
Thank you. Mr. Fox, anything that you'd like to say?
Yeah, I thought we established this back in the past with Elsie. She is not my child. I did not even sign the birth certificate to her or any of that. And when the old past, she tried to get child support from me for Elsie, they took care of it because of her not being my daughter. And now you guys are going back after me for child support. You know, her real father works full-time. He has a full-time job. You know, I think, to be honest, he should be the one that should be paying the child support, not me.
Well, there was a judgment of divorce that was entered last year that indicated you guys are the parents of the child. You have the right to potentially file a revocation of that paternity, but you need to take those steps. That requires a specific filing with the court to revoke that.
And I don't understand that stuff, sir. I was in special ed through school. I don't understand that kind of stuff.
Well, there's potential options to get assistance out there, as well as getting an attorney to help you. So there are avenues available.
I can't afford attorney. I can't afford none of that.
All right, there are other potential options to learn the steps and how to do that. I cannot certainly do that for you. But we have a situation here where, you know, there was a judgment put in that said you were the father. You would need to take the necessary steps if you want to challenge that.
I would never signed anything as I was the father to her. She put me down on all that. I never was involved with none of that.
All right, well, there was a default judgment entered. I don't know, again, what the process was there, but that's the court order that controls. You might be able to challenge potentially that also. But I have to go with what's in front of me as far as what's been ordered and declared on orders. Like I said, you have some potential avenues that you could take. But it sounds like, sir, that then you are receiving Social Security. Is that correct?
Yes, sir.
There's an income withholding order that we are waiting to start collecting payment on. Is that correct? All right, in front of the court indicated that there's an income withholding order that's going to hopefully start collecting. What I'm going to do is adjourn this matter out just to make sure that that is happening. I will adjourn we'll go out a couple months, just give time for all that to happen. I'm going to adjourn to May 14th.
Now, if you guys are taking my Social Security, if I'm paying for a child that's not mine, I hope you guys pay me that back.
Well, sir, there are avenues that you need to take because there's a court order that says these things. So
yeah, but this was taken care of in the past. This was established a long time ago, sir.
Okay, I'll review that prior file with the
because
file
Dave Leonardson took care of it. Kevin Hessling took care of it.
Okay. If that paperwork is there, then bring that into the front of the court, and that would change it. But in this file, and again, I don't know the full history of the file, but this file has an order that indicated that you were the father and that you were to pay support. Okay. All right. Thank you for appearing today, sir. Back here on May 14th. Or sorry, May 14th. you'll get a notice for that.
This matter was adjourned from February 12th to monitor the defendant's payments. He has a monthly support obligation of $1,040 with an additional $50 ordered on arrears. His current balance on his account is $42,349, which does not include the most recent payment made just a few days ago of $1,200. Previous to the most recent payment, he paid $76.59 in January. I have been in contact with him. I think considering he has now started employment and has an understanding of what is expected of him, I'd like to just adjourn to monitor to make sure he continues to follow through on his end.
Thank you, Mr. Zazadny. Anything that you would like to say?
No, I'll be more on time with the payments. Now, like I said, I'm working again, so I'll have the next payment in by next month again.
All right, so you think you can start meeting that monthly payment every month?
Yes, sir.
Ms. Green, any questions or anything that you would like to say?
No, I think everything should be good going forward.
Okay, all right, we'll adjourn the matter out then to June 11th, just to make sure all those payments are happening. If we have paid every month, when we get to that time, then we would cancel that hearing, okay?
All right, sounds good. Thank you.
Thank you both for appearing. You can sign off. Archer versus Kenneth Straight, file number 24-19633DM. Do you have anyone present on that matter?
I'm present, Your Honor.
Good morning, sir. In front of the court, what is the status of this matter?
Your Honor, the defendant has a monthly support obligation of $119 and a current balance of $2,552.59. Last payment received was in February in the amount of $125. Previous to that, December, in the amount of $250. We would like to just adjourn to continue to monitor the payments.
Thank you. Mr. Straight, anything that you would like to say?
No, sir.
All right, you're gonna be able to keep meeting that monthly amount at least, sir?
Yes, sir.
All right, we'll adjourn your case then to June 11th to monitor your payments, okay?
Thank you.
Marlene Manusco versus Wayne Manusco, file number 20-18088DM. Do the parties on that matter present?
Yes, Judge Elliot Blumberg on behalf of Marlene Manusco, who's appearing via Zoom from my office.
Thank you.
And yes, so representing myself at this time.
All right, Mr. Blumberg, this is your motion to extend child support, is that correct?
Yes, Judge, that's right. These parties were divorced in September of 2022. The judgment of divorce didn't really address any post-majority support for the Ashlyn, who is the youngest of these children. She is now 18 years old, is a senior in high school, and is on a full-time basis. She has a reasonable expectation of completing her credits. She should be graduating in June. Mr. Manusco stopped paying child support in January upon her 18th birthday. So we are in the court, and we have cited the statutory authority for the request to extend support until graduation.
All right, thank you. Mr. Manusco, what is your position on that request?
Well, Your Honor, as of this date, I have not received the motion from the plaintiff's attorney. So it's pretty hard for me to, dispute something that hasn't been delivered.
He filed a response, Your Honor.
Yeah, because I got an email from my ex-attorney saying, hey, you got court coming up. So I filed a response. That is correct.
All right,
but I do not have.
Let's discuss what was said. So, sir, do you agree that the child is regularly attending high school?
At different times, she's talking, she might want to drop out. So.
All right.
All
now
the
what she
things
wants,
for me.
is she currently in high school?
She's currently in high school, yes. And school gets done for seniors in May.
Okay. Do you have any reason to believe that she is not expected to graduate in May?
Well, with the stress that goes on in their lives, I don't know. I can't make somebody else's decisions for them. I would hope she finishes school.
All right, Mr. Blumberg, you indicated Ms. Manusco is with you.
Yes, she is.
I'm going to take just some brief testimony from her. Ma'am, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Ms. Manusco. So is it correct that Ashlyn is regularly attending high school and has a reasonable expectation of completing sufficient credits to graduate?
Correct, yes.
And does she reside with you full time?
Yes, she does.
All right, and she turned 18 in January, is that correct?
That is correct.
And is it expected then that she's going to graduate this year?
Yes.
All right, thank you. Mr. Manusco, anything else that you wish to say?
Not besides, I don't have the paperwork to either seek counsel or help me on my behalf.
All right, well, the paperwork's pretty straightforward. It just indicates that the child has turned 18, the child's in high school, has an expectation of graduating, resides with Miss Manusco. And then it cites the statute which discusses extending support beyond an 18th birthday when a child is still in high school and is expected to graduate. So anything else you wish to say, sir?
Well, yeah, and back in mediation, this was a derivative of the family court policy that we agreed upon in mediation back in 2021.
What did you agree? You
So-
agreed to mediation, not pay support beyond her 18th birthday?
Correct. That's why it never got dropped for my prior daughter, Nicole. Support stayed the same through the continuation of 18.
Your Honor, if I
All
could
right.
address that, as a part of a property settlement, it was agreed that Mr. Manusco's obligation of $900 a month would continue until the last child. It wouldn't reduce at a later date. But again, it was silent on any post majority support.
All right, well, I mean, the post-majority support statute is pretty clear. There's nothing to indicate that the parties had some type of agreement not to have post-majority support. And even support is ultimately based on what is in the best interest of the child. So I do find that the terms of the post-majority support statute have been met, and I would grant the motion to extend through May of 2025.
Thank you.
Any questions? Mr. Manusco, any questions?
What about my recalculation for medical insurance? Because my daughter Ashlyn would, I guess, like to keep medical insurance.
You're requesting what, sir?
Well, there's I'm on a fixed income, obviously, because I'm retired. So
Okay.
due to that the medical insurance has skyrocketed this past year to $537.79, I asked that the court would recalculate child support based on the amount of medical insurance coverage is being provided.
Okay. So, Mr. Blumberg, as far as a request to recalculate, what is your position?
The judgment of divorce, again, established a support amount of $900 per month total, regardless, not being affected by any additional increases or decreases or any other expense. That's what the property settlement contemplated. That's what the judgment provided. It's $900 a month. The fact that his health insurance costs may have gone up is of no consequence. That was the negotiated amount.
Well, Your Honor, it is a consequence because my daughter would like to still keep medical insurance.
I don't understand what that means, sir. So,
Well, according to the family court, in front of the court, I'm only allowed or supposed to pay up to 6% of my annual income for insurance. I've exceeded that in the first month in January.
Well, Judge, Mr. Manusco chose to retire at age 50. He has not worked in the last 5 years. This is all, he's a healthy individual that could work. He chooses not to.
I disagree. You don't see me get out of bed, Your Honor.
all right, well, let me just take a look through. I mean, unfortunately, this case has got 7 files. I don't have all of those with me, so I don't have the judgment of divorce with me. So, Mr. Mccluskey has filed a motion regarding support, asking for a recalculation. I am going to review the file, and then I will submit a written recommendation on whether or not we're going to grant a review of the support. I need to see specifically what those terms of the judgment of divorce discussed. So I will grant the motion, the post-majority motion, and then I'm going to do a written response to the motion regarding a new preparation of a new recommendation.
Judges,
Any questions, Mr.?
Yeah, are you going to prepare the order or shall I?
I will, Your Honor. We will.
Okay.
Mr. Plummer.
Thank you.
Thank
That's
you.
your,
Mr. Mccluskey? Any questions, Mr. Mccluskey?
Nope, I think I'm satisfied for now.
All right, thank you for appearing. You're both all set and can sign off.